My lady, my lords,
Just give me a moment, would you?
Certainly.
Yes.
My lady, my lords, I appear for the appellants, to whom I'll refer collectively as GW, with Mr. Bala. You may have seen from our papers that we were due to be led by Mr. Strange. He conveys his apologies, having caught COVID on Monday. Though rest assured, we have tested all of our team and fortunately had not spent time with him in person in the recent days. Mr. Sagan, Casey, and Mr. Mehta appear for Otsuka, the respondent. Just a brief housekeeping note. The judge below gave an order with respect to the confidentiality of certain of the documents, and you have a confidential bundle before you. On neither side do we anticipate having the need to make much, if any, reference to those confidential documents. But if we do so, we may need to request the court's leave to move to a private hearing for that purpose.
Well.
Turning to the structure that I propose to follow this morning, first of all, I propose to set out brief factual background as relevant to the appeal, and then to deal with grounds 1 and 2 on Mozambique, and somewhat more briefly with ground 4 on forum non-conveniens, on the basis that I will have touched upon some of the relevant points while dealing with Mozambique. Mr. Bala will then deal with ground 3 on act of state and public policy. So, factual background. Otsuka's claim relates to a pharmaceutical product, Epidiolex, which contains the active ingredient cannabidiol, or CBD. And Epidiolex was approved by the FDA in 2018 as a treatment for rare but severe forms of childhood onset epilepsy, and approval later followed in other jurisdictions. Otsuka maintains that under a research and collaboration agreement, commonly referred to as the RCA in these proceedings, that the parties entered into in 2007, it is entitled to royalties on the sales of Epidiolex. Because, so it argues, Epidiolex is covered by valid claims of certain patents that were issued as part of the parties' collaboration under the RCA. This includes, in particular, the parties' US 920 patent, which we say is the leading patent in dispute. The parties executed the RCA in July 2007 for a 3-year term, and that was later extended for a further 3 years in 2010. Generally, the RCA involved collaboration between the parties to evaluate a range of different cannabinoids as potential drug treatments for CNS diseases, central nervous system diseases, and cancer. The contract is expressed as governed by and to be enforced in accordance with New York law, and that's at section 16.4 of the contract. And insofar as disputes were concerned, the parties agreed first and foremost to refer any material disputes between them to their respective senior management for attempted good faith resolution over a period of 30 days, and failing that, to refer certain classes of disputes to international arbitration in New York if GW instigated, or London if Otsuka did. In either case, and regardless of the seat of any arbitration, the parties agreed that they would be entitled to all discovery in like manner as if the arbitration were a civil suit in a New York court. However, the parties expressly excluded from their arbitration clause any disputes relating to patent scope, validity, or infringement. Now, I will come back to the significance of these choices of governing law and regarding jurisdiction in due course. In brief, we say they are significant as a matter of assessing several of the English authorities before you today, as very often the presence of an English jurisdiction clause had a key role to play in the approach taken with respect to Mozambique. We also say that these choices are significant in the assessment of ground 4 on forum non-conveniens, in particular in circumstances where important questions of New York and US federal law, as applicable in New York, arise in these proceedings, and in circumstances where what is carved out of the parties' arbitration clause is not just questions of patent validity, as is often seen, but also questions of patent scope and infringement. The parties' collaboration under the RCA continued until the expiry of that agreement as extended in 2013. In May 2019, Otsuka first alleged that Epidiolex was a product the subject of the RCA on the basis that it was a product covered by a valid claim under the parties' joint US 920 patent. Over a year of negotiations followed, focusing on these contentions with regard to US 920 and involving senior management and New York counsel on both sides. Both then as now, GW maintained that the claims of the US 920 patent do not cover Epidiolex, but if Otsuka is right on its claim construction and Epidiolex is covered, then that construction of those claims would necessarily render them invalid for reasons to which I will revert in due course. Moreover, US 920 is not listed in the FDA's Orange Book as covering Epidiolex or its FDA-approved methods of use. The patents listed there for Epidiolex are patents owned by GW alone. In June 2021, Otsuka initiated arbitration under the RCA, claiming royalties under the US 920 patent, and for the first time also under a European patent, EP637. That arbitration is ongoing, with GW challenging jurisdiction on the basis of the carve-out of the parties' arbitration clause, and Otsuka maintaining it may nevertheless proceed in the arbitration with an equitable estoppel claim under New York law. In October 2021, Otsuka filed these proceedings, again seeking royalties under the RCA on the basis that Epidiolex is covered by a valid claim of the parties' joint patents arising from their collaboration. And at that point, in addition to US 920 and EP637, adding claims with respect to an additional European patent, 2 Australian patents, an Israeli patent, and a UK patent. Now, we say that Otsuka's initiation of proceedings here was in spite of the fact that the true centre of gravity for this dispute is New York. And there are a number of reasons for this. 95% of all sales of Epidiolex up to the end of 2021 were affected in the US. In other words, the royalty-bearing activity. The US is and is expected to remain the dominant market for the drug. US 920 is accordingly, we say, the lead patent at issue. The RCA is expressly governed by and to be enforced under New York law. And reflecting all of that, all interactions on this dispute between the parties from May 2019 until the initiation of proceedings here in England were handled by New York counsel on both sides. Accordingly, GW brought its jurisdictional challenge on the 24th of December 2021 and filed proceedings in New York on the 7th of January 2022, which were then served in February 2022. The challenge to jurisdiction here was heard on the 4th of March, resulting in the judgment of the 3rd of May and permission to appeal to this court on the 11th of July. By way of update, the pleadings are now completed in England as of May-June 2022. A CMC is set for mid-November 2022, with discussion on the disclosure review document ongoing, and trial is fixed for January 2024. In New York, there is a general directions hearing next week, which is expected to resolve, among other things, an application by Otsuka to delay discovering, pending a motion to dismiss that it filed on the 13th of May 2022. There is no date for hearing of the motion to dismiss as yet. So having set some of the background, I'll turn now to grounds 1 and 2 with regard to Mozambique. And the first thing we say is that patent validity is squarely in issue between the parties in 2 ways. And to do that, I will ask you to turn to the New York complaint, which is in the supplementary bundle behind tab 11. So if we could, just in passing, if I could ask your report to turn to page 142, since we are dealing with jurisdiction, I'll just draw your attention to the points that are made there on the jurisdiction of the New York court. There was a series of arguments starting in paragraph 11 with a discussion of the fact that the RCA and a predecessor agreement between the parties are governed by New York law and contain the dispute resolution provisions that I've told you about. If you go over the page at paragraph 16, you see reference to Otsuka transacting business in New York. Further down the page at paragraph 19, that includes collaborating on clinical trials of drugs in New York. Over the page on page 144 at paragraph 21, there is reference to the presence of personnel in New York. And then fifthly, at paragraph 23, reference to an Otsuka subsidiary in New York. I draw your attention to those points in passing, as we may come back to them in due course on the questions of forum. If I could therefore ask you to turn to page 160, this is using the appeal bundle pagination, and this is where we get into the merits arguments in the New York complaint. And you see it starts with heading A, GW Pharma does not owe Otsuka royalties because Appellant is not covered by any valid claim of the asserted joint patents. And this, as we say, is raised on two distinct bases. You see the first basis in paragraphs 90 and 91, which is a point on obviousness. Claims 1 and 2 of patent 920 have already been found unpatentable as obvious, and the argument is therefore made that claim 6, on which Otsuka's claim must necessarily therefore proceed, is unpatentable for the same reason. If you go over the page, the second validity point that is made here, and this is at paragraph 94, is that if Otsuka is correct on its claim construction of US 920, that would make claims invalid for lack of written description and non-enablement. If you go from there to 164...
Could we just have a moment just to take in paragraph 90?
Certainly. And going from there to 164, heading B, in some senses this might be the flip side of the coin. So the second argument made is that GW Pharma does not owe Otsuka royalties because any claim of the asserted joint patents construed to cover a PDLX would be invalid. And you see here in 102 and 103, the same argument is made that if Otsuka is right in its construction arguments, then the claims would be invalid for non-enablement or description issues under USC 112, and that's in paragraphs 102 and 103. And you see in paragraph 103 reference to the Lear Doctrine, and I will take you to that case shortly. And if you then go over the page to page 165, for some reason the order of the two validity issues is reversed in this argument, but you see there at paragraphs 106 to 108 that the obviousness validity question is raised again. And we say that is a validity question that arises regardless of claim construction. It proceeds on a previous revocation of claims 1 and 2 of the US 920 patent. If you go from there to page 173, you see the consequence of all of this. So at the top of the page at paragraph 132, the relief that GW seeks is set out, with the primary relief being that either the asserted patents do not cover a PDLX, or in the alternative, if they do cover it, they are invalid. And at the bottom of the page, you see the prayer for relief. And on page 174, the declaratory relief A and B that is sourced in the New York court.
Can I just go back to 161?
Certainly.
And could you just, I think I understand what this means, but just so I'm clear, what does invalid for lack of written description and non-enablement mean?
I say this.
I can follow written description, but what does non-enablement?
I think the point, my lord, is that the description given in the US 920 patent is insufficiently specific based on the knowledge at the time, to actually enable somebody to prescribe the drug for the uses in question. I may come back to you on that, my lord. We have a colleague in the US who is assisting us with instructions on these points, so I may come back to you in reply, but that's my understanding as an English lawyer.
Yes, do we have to understand that clearly in order to appreciate and evaluate your invalidity argument?
I'm not sure that you do, my lord. I think simply it's a question of are questions of validity sufficiently directly at issue here for Mozambique to be engaged? And we say they absolutely are, and there are at least two different ways in which they are. One is in relation to claim construction, the other is obviousness.
Okay.
Yes.
Well, let's see what happens.
Thank you. So yes, so as I've said, there are two planks to GW's invalidity case. One proceeds on the basis of obviousness under 35 USC 103, and we say exists independently of the points Otsuka maintains on claim construction. And we also say that this was wrongly overlooked by the deputy judge in his judgment. The second proceeds on the basis that Otsuka's claim construction would render the patents invalid for lack of description or non-enablement under 35 USC 112. On that second challenge, and notwithstanding Otsuka's attempts to characterise it as incidental only, we say it arises in any event on Otsuka's positive claim, which assumes validity as a necessary building block, as well as being a central component of GW's defence. With respect to both planks of the invalidity case, the doctrine in Lear applies, and I propose to move to that now. That case and its progeny occupied a substantial volume of witness evidence in the proceedings below. In basic terms, Lear involved a debate between an inventor and a licensee company exploiting and selling gyroscopes to the aviation industry. And that dispute was determined in the Californian courts, who ruled that an invalidity defence was barred by licensee estoppel. In other words, an old doctrine that a licensee operating under a license agreement is estopped from denying the validity of his licensor's patents in a suit for royalties. The matter came before the US Supreme Court, and that decision is at tab 17 of the Joint Authorities Bundle. If I could ask the court to turn to page 732 of the bundle pagination of that decision. And I'm going to start in the left-hand column, just under the Roman numeral 3, paragraphs 6 to 7. And you see the court there address the question before it. The uncertain status of licensee estoppel in the case law is a product of judicial efforts to accommodate the competing demands of the common law of contracts and the federal law of patents. And a bit further down the same paragraph, when faced with this basic conflict in policy, both this court and courts throughout the land have naturally sought to develop an intermediate position which somehow would remain responsive to the radically different concerns of the two different worlds of contract and patent. The result has been a failure. And so they seek to resolve this failure on the next page, page 733. And if we pick up the narrative at paragraph 8 in the left-hand column, even in the more typical cases not involving conscious wrongdoing, the licensor's equities are far from compelling. And at the bottom of that paragraph, final sentence, although licensee estoppel may be consistent with the letter of contractual doctrine, we cannot say that it is compelled by the spirit of contract law, which seeks to balance the claims of promisor and promisee in accordance with the requirements of good faith. And here is the balancing exercise. The equities of the licensor do not weigh very heavily when they are balanced against the important public interest in permitting full and free competition in the use of ideas which are in reality a part of the public domain. and that thread is continued at the top of the next column. If they are muzzled, the public may continually be required to pay tribute to would-be monopolists without need or justification. We think it plain that the technical requirements of contract doctrine must give way before the demands of the public interest in the typical situation. And you'll see they then formally overturn a previous decision. If you could go over the page, and starting again on the left-hand column, page 734 in the external pagination, at the very bottom of the column, while the equities supporting Adkin's position are somewhat more appealing than those supporting the typical licensor, we cannot say that there is enough of a difference to justify such a substantial impairment of overriding federal policy. And in the next paragraph at the top of the right-hand column, they refer to the existence in that case of a contractual entitlement for royalties to be paid until such time as the patent is held invalid, noting that the fact remains that the question of patent validity has not been finally determined in this case. And therefore the suggestion was made that Lear should continue to pay while patent validity was resolved. In the middle paragraph in that column, they say the decisive question is whether overriding federal policies would be significantly frustrated if licensees could be required to continue to pay royalties during the time they are challenging patent validity in the courts. And their conclusion then, and this is in paragraph 10, that would have a stifling effect, contrary to the public policy invoked, and therefore they reject the idea that royalties should continue to be paid. Now, there were a number of other decisions before the court below. I don't need to take you to all of them, you'll be pleased to know, but by way of context, want to show you some discussion of them. And this arises in Mr. Diamond's first witness statement, which is behind tab 2 of the supplementary bundle. Mr. Diamond was a witness for GW in the proceedings below on questions of New York and US law. If we take up the narrative at page 16 of Mr. Diamond's witness statement, he starts at Roman numeral 3 with a summary of the entitlement to a certain validity under the Lear Doctrine, noting in 13.1 that the Lear Doctrine is applicable in New York as overriding federal law, and you'll see it at footnote 2, there's a reference to the Constitution of the United States, by reason of which federal law is applicable in all of the various states. Going over the page at paragraph 13.2, he refers to the points I alluded to earlier in the factual chronology that since the outset of the dispute, Otsuka has been on notice of the validity questions that GW raises. And in 13.3, he raises the symbiosis that I've already discussed with you between claim construction and invalidity on the other hand. In paragraph 14 and going over the page, he then summarises Lear and its import as a matter of US law, further to which on page 19 in paragraph 15, he then refers to a further US Supreme Court decision, Medimu, which is not in the bundles before you, but I draw to your attention simply because it confirmed Lear in 2007. And he then, in paragraphs 16 through to 19, deals with several cases in which Lear and the Lear Doctrine has been followed in both federal and state courts, including a reference in paragraph 19 to another important case from GW's perspective, which is the Lemelson Decision. That decision is in the Joint Authorities bundle at tab 19, and if I could ask you, you can put Mr. Diamond aside for a moment, and if I could ask you to turn that up, please.
Did you give us the number? Sorry.
19 of the Joint
Thank
Authorities
you.
bundle. And the discussion starts page 761 of the bundle pagination in the right-hand column. There's a head note there which provides you with a factual summary of the case. If you'd like, if the court would like to read that to yourselves. And then there is a summary of the key findings, which for our purposes is number 2 in the right-hand column. Essentially that the principles in Lear apply equally to co-owners, which is obviously the relationship between GW and Otsuka under the RCA. If you turn from there to page 764, you see the reasoning and the express application of Lear, starting in the left-hand column at paragraph 2 with the heading, the application of Lear. And at the top of the right-hand column, again, reference to the supremacy of federal patent policy in Lear. And there's a quotation from Lear. And then going over the page to page 765. There is the reasoning in Lemelson in the left-hand column about a third of the way down. Lear clearly held that removing the restraint on commerce caused by the exercise of an invalid patent is more important than enforcing a promise between contracting parties. So here the doctrine of estoppel must give way to the federal policy of unencumbered challenges to patents believed to be invalid. Public interest in the validity of all outstanding patents allows scrutiny of the 566 and 271 patents, unconstrained by the contractual relationships between the parties, which in that case was a co-owner relationship equivalent to that here. So with that, I want to turn, my lady and my lords, to English law and to take up Chugai, which will no doubt be familiar to you. And it is at tab 15 of the Joint Authorities bundle. And just starting on page 647 of the pagination, we say that although Chugai is very helpful to you, there are two key distinctions between it and the case before you. The first of those is referred to in paragraph 21 on page 647, namely that in that case there was an exclusive English jurisdiction clause and an English governing law clause. And the second of those distinctions appears on page 648 at paragraph 25, as well as elsewhere in the judgment.
Just on the law clause that you referred to, remind me, I thought in Chugai, the law that was applied to consider the validity of the patents or the infringement of the patents, when it was done, if it was American law.
Yes, I think that's right.
So the proper law of the contract was English law, but that didn't mean the court doing what Mr. Justice Carr decided to do in that case wasn't going to look at US law, US patent law.
That's correct. And out of the two elements that are referred to there in paragraph 21, I would emphasise the exclusive English jurisdiction clause more so than the governing law clause, but I will come back to that.
So forgive me, you did give me two references, 21 and the other reference. I'm
Sorry, I beg your
It
pardon.
might be-
Paragraph 25, and that was that, and this was something that counsel was very careful about in that case, which is that it was no part of Chugai's case that the relevant US patent, so 271 in that case, was invalid. And Chugai did not seek any relief, so nothing like the declaratory relief you see in the New York proceedings here as to invalidity. And therefore, the effect of US invalidity was incidental to the determination of the contractual question and was only relied upon in support of construction. There is then, in the judgment, substantial discussion on the question of whether, in the circumstances of that case, there was an attack on validity for the purposes of the challenge to jurisdiction there. And at page 649, the judge dealt with two cases that had come before Mr. Justice Arnold, as was the Annan case and the activist case. Both of those were under the European regime, which is obviously a distinction with our situation here. We're dealing with the Mozambique rule under common law. But as you'll have seen from our skeleton, we say in terms of the facts, we're closer to the first of them than we are to the second. The first is dealt with in paragraph 28. And essentially, while there was an invalidity challenge at the place of the patent in Germany, the claimant had sought to bring proceedings here on infringement. And you see at E along the side the quotation from Mr. Justice Arnold's decision, and essentially he found that those issues were inseparable. It was impossible to distinguish between validity and infringement in circumstances where there was a live validity challenge in Germany. And at paragraph 29, Mr. Justice Henry Carr found that that decision illustrates that the court should carefully examine the substance of the dispute in the context of the European regime, and also that not every infringement dispute is concerned with or principally concerned with a challenge to validity of the patent in suit. For example, if a party has undertaken not to challenge validity and only to pursue a case of non-infringement. And then in paragraph 30 and subsequent paragraphs, there's a summary of the activist case, which was one such example. And we would say is a million miles away from where we are here, where validity is squarely put in issue. So summarising the position in Chugai at paragraphs 33 and 34 on page 650, the judge, reflecting the fact that there was no direct challenge to validity, considered that the questions of validity insofar as they arose were subsidiary or ancillary as an aid to construction of the patent and did not go beyond that. And you see there in paragraph 34, he considered that he would accept Chugai's submission that this merely required the court to ask itself as a guide to construction what would be the hypothetical consequences for validity of the rival interpretations. If we could jump from there to page 6.
So just before we leave that, so do you accept that there the judge is contemplating a case in which the court deciding the issue he's referring to will be considering validity, albeit on a hypothetical basis?
Yes, I do, my lord. In the Chugai case, validity was insufficiently directly in issue for there to be a Mozambique objection, and that is because it arose as an ancillary or an aid to construction on a hypothetical rather than as a plank of relief. And I will come to our submissions on the appropriate measure in due course, but we would say that it is a question of degree and what is raised on a given case. So turning to 654, the judge then went on to discuss the rule in Mozambique, and he started with a discussion of Lucasfilm. My colleague Mr. Vala is going to take up some discussion on Lucasfilm on active state, so I don't propose to go to that decision, although it's obviously important. I'll pick up the discussion with Mr. Justice Henry Carr on paragraph 53, where he noted that the modern trend is obviously in favour of the enforcement of foreign intellectual property rights in the English court, where validity is not challenged and there is no issue of policy which would militate against enforcement. It follows that the rule in Mozambique, in its attenuated form, does not affect the jurisdiction of the English court in respect of claims of infringement for foreign copyrights. And that is, of course, a reference to the fact that the Lucasfilm case was, in fact, about copyrights rather than patents. And then he picks up the discussion further at paragraph 54. Mr. Layton submits, and I accept, that the Supreme Court in the Lucasfilm case did not decide that the issue of the validity of foreign patents, which were outside the scope of the European regime, were justiciable in the English courts. And there's a quote there from Lucasfilm which essentially leaves the question open, and then a reference to Dicey, endorsing the idea that it remains open to be decided whether questions as to the validity of a foreign patent are matters which are non-justiciable before an English court. There's a discussion in paragraph 55 of a contractual exception to which I will revert in due course, as there is a point taken against us on that. But for now, I would just draw your lordship's attention to his decision on Mozambique, which appears at page 657, paragraphs 57 through 60. And his first reason is there was no direct contention of invalidity. Invalidity was pleaded as no more than an aid to construction, and accordingly would only arise incidentally, per paragraph 58. The proceedings were therefore properly characterised as a contractual claim for a declaration that no royalties were due, which arose irrespective of the validity of the relevant patent. And finally, at paragraph 60, he noted that there was an exclusive English jurisdiction clause which assisted on the possibility of an affront to comity for the purposes of the Mozambique rule. Before moving on to discuss the import of that a little bit further, just ask the court to turn up commentary on Briggs, the 7th edition, in relation to this case law, which is at tab 24 of the Joint Authorities bundle, page 866. It's just a brief passage, but we say it is insightful. And it's the second paragraph on the page, starting with the approach in Birss and Ove Arup. So this is a discussion in relation to Lucasfilm, and approximately a third of the way down that paragraph, Briggs's view is that a fair reading of the judgment, and that's the judgment in Lucasfilm, would suggest that where a genuine dispute over the validity of a patent is raised, whether as a claim or as a defence to an allegation of infringement, the exclusionary rule, meaning the rule in Mozambique, may still apply. And there is a footnote there to Chugai and the finding that the exclusionary rule still applies to proceedings which involve a direct attack on the validity of the patent, but it does not impinge on simple infringement claims. So that is Briggs on Lucasfilm and Chugai. So turning to the substance of grounds 1 to 2 of our appeal, as you will have seen from our grounds of appeal and skeleton argument, we challenge both the test that the Deputy Judge applied with respect to Mozambique and his application of that test. On the former, he restricted the application of Mozambique to challenges to validity that are direct in the sense that they raise questions of validity as the first, and in that sense, primary issue in the claim. That's not where the line was drawn in Chugai. Instead, there was a rejection there of Mozambique, where the validity attack was only incidental and a matter of hypothesis when testing claim construction. And it is wrong and artificial in our submission to reduce the test in that way. the true centre of gravity of a dispute is often a point that is subsidiary or logically anterior within the hierarchy of arguments. But the judge's finding would be unprincipled in the sense that it would result in parties adopting illogical hierarchies in the way in which they articulate their claims or defences to get around it. Alternatively, it might mean that parties particularly concerned about a validity point should not raise all potential arguments available to them, but only those on validity. Our submission is that the principle following the commentary in Briggs is that the exclusionary rule in Mozambique should apply where there is a genuine dispute over the validity of the patent, whether as a claim or as a defence to the allegation of infringement. In other words, a validity attack may rise to the required threshold, even if it arises later in the logical chain of reasoning. Now, one could say that that would open the floodgates to a raft of unmeritorious validity arguments posed as jurisdictional challenges. And we would say the answer to that is in the word that Briggs has used, genuine, meaning something that is not flimsy or an obvious contrivance designed to avoid jurisdiction, but something that has a reasonable prospect of success. Insofar as the application of the Mozambique principle is concerned, we say that the judge erred in failing to account for the existence of a validity challenge that exists independently of any claim construction issue. In other words, the obviousness challenge. We also say the erred in overlooking...
Sorry, why is obviousness independent? I don't understand that.
It does... So the two validity challenges that are put in the US proceedings and here, one of them arises if Otsuka is correct in its construction of the claims of the patent. That in turn would, we say, mean that those claims must be invalid. So the two are in symbiosis with each other. In contrast, the obviousness challenge to the patent arises because of prior decisions of the US PTO in relation to the unpatentability of claims 1 and 2 of US 920. So it arises independently.
Okay, let me tell you what I thought your case in the US was. I thought your client was running both arguments in the US, and what I mean by both is that for any of the validity challenges, whatever they are, whether it's obviousness or written description or enablement,
yes,
it was being said that the claims were just invalid, which is the independent point, and it was being said that if which you deny the claim to be a large product, then they would be invalid on all of those grounds.
I'm sorry,
I thought both the linked arguments and the independent arguments were being run in relation to all the grounds. I didn't think there was a difference between obviousness and the others. That's why I reacted when you put it that way.
I understand, madam. I think the distinction is simply this. It could be said against us that the invalidity arguments, so far as they arise on claim construction, are more like Chugai. In other words, they're an aid to construction.
Absolutely.
But there's a proper claim put in place and a plea for a declaration of invalidity there. The point about the obviousness challenge is it arises independent of the question of whether the interpretation of the patent claims is correct or not.
Okay. As I said, I thought in your complaint, in your client's complaint, it was also put on the same alternative, if then alternative basis. But it may not matter very much from the point of view of your argument.
Thank you, my lord. Yes, so we say that this case bears clear analogy to the position in Annan and Molly Court. In other words, that invalidity and validity are two sides of the same coin. And to put it another way, Otsuka's case rises and falls on the question of it demonstrating validity. The questions of validity will also likely require considerable time. They occupied substantial space in the witness statements just for a jurisdictional challenge in the proceedings here. And we therefore say that the deputy judge could and should have safely concluded that the validity defence would feature very prominently in the proceedings. The only other point the deputy judge referenced was estoppel, and you will have seen in our skeleton we have referenced the fact that it is barely pleaded in the English proceedings, there was an additional assigner estoppel theory put forward in the jurisdictional challenge, to which I'll turn momentarily, but that is as yet unpleaded here anyhow. And in any event, we would say that estoppel contentions are unlikely to feature prominently and not usually dispositive of cases. So with that, I wanted to move on to deal with three of the key points that are made against us on Mozambique. And the first of these is the what we would call the extended contractual exception. And this was a new point that was raised for the first time in the respondent's notice behind tab 3 of the core bundle. Thus, it was not a point that was before the judge below. Otsuka now maintains that proceedings before the English courts concerned with patents will only infringe Mozambique if they raise validity directly and also are not based on a contract or equity between the parties. That argument is made forcefully in the respondent's skeleton at paragraph 43. We say this is effectively an argument that as soon as a party invokes a contractual or equitable right, Mozambique does not apply at all. That rather begs the question as to why all of the debate in Chugai and prior case law and commentary even exists, as it would be a silver bullet. As soon as there was a contractual or equitable basis for a claim, there would be no place for Mozambique at all. So we say that that substantially overstates the position, and that none of the cases that the respondent cited articulates an exception to Mozambique in terms even close to that all-encompassing. And if I could ask you to turn up Chugai again, I will just give you two examples of this. Chugai, by way of reminder, is it behind tab 15 of the Joint Authorities bundle. And the judge there dealt with the contractual exception in two places, the first of which is at the bottom of page 653. At paragraphs 46 and 47. He deals with a decision in Briggs, which is one of the decisions that Otsuka now relies upon. And if you'd perhaps like to read those to yourselves. So we would say that a key, if not material, feature of the contractual exception to Mozambique in Briggs is the presence of English jurisdiction clause and an English governing law clause. He talks again about this contractual exception in paragraph 55 of the decision, which is at 656. There says there are certain long-standing exceptions to the rule in Mozambique, referring back upward, mentioned that he'd already dealt with the Griggs case.
I'm sorry, which paragraph number are you on now?
I'm in paragraph 55, my lord.
Sorry, thank you very much, yes.
Bottom half of page 656.
Yes.
And he quotes from Stevens and Hammett. Which in turn quotes from several of the other relevant decisions on this contractual exception. And I would draw your attention in particular to the part embedded in the quote at paragraph G. So we would say the exception is where the suit arises out of contract or implied contract or fiduciary relationship or fraud. that does not depend for its existence on the law of the locus of the immovable property. And indeed, I've shown you this already, but at paragraph 60, when the judge reaches his decision on Mozambique, he regards the presence of an English court jurisdiction clause in the Chugai case as being determinative of whether what he calls the long-standing contractual exception to the Mozambique rule applies. So, in other words, we say that to suggest that the Mozambique rule can be disapplied simply because of the existence of a contract on which a claim proceeds puts it far too high, and really the determinative or key factor in that exception is whether or not English law applies and an English jurisdiction clause is in play.
Just in the quote from Stevens and Hammond, sorry to be simple-minded about it, but I don't see a reference to an English choice of jurisdiction clause. It doesn't appear to be what they're talking about, what Justice Lloyd Jones, as he then was talking about. He's talking about the existence of a contract or some other in personam obligation, but I don't see, just help me, I don't see a reference to...
Yes, quite right, my lord. So I suppose I put it in the inverse then. The reference that we would rely upon there is toward the end of the paragraph.
Mr. Justice Parker.
Yes.
I was trying to understand exactly what that meant. What is it what the phrase "do not depend for their existence on the law of the locus of the immovable property"? What is it that does not? Not quite sure about the punctuation. Safe to criticise a judge's punctuation. 114 years on, I think.
Quite.
Could you parse that sentence for?
Yes. So my submission, my lord, would be that the contractual exception may apply where there is something that is purely contractual or potentially even equitable arising before the English court that it otherwise has jurisdiction to deal with, but the court may then lose jurisdiction insofar as the immovable property, and here we have to be talking about patents, although I'm not sure that that was what was an issue then, but that immovable property depends for its existence on the foreign.
So it's the personal obligation
yes.
arising, for example, from a contract, which doesn't depend for its existence on the law of the locus of the immovable property.
Yes.
And you say this case falls outside that.
Yes. And indeed that we say that that was the way in which Mr. Justice Henry Carr approached the contractual exception when you look at paragraph 60, because in particular he invoked the existence of an English jurisdiction clause. But also he had already determined that validity wasn't squarely an issue. So the two things go hand in hand.
Why does the obligation in this case depend for its existence on the law of New York?
Insofar as Mozambique may be said to apply to patents, the challenge to the validity of US 920 is something that proceeds under US law, and therefore we say can be subject to the New York court's jurisdiction. It could equally be another court in the US, but it's a patent issued by the United States Patent Office. And it depends for its existence. US patent law.
Can I just put to you an alternative view, which is that the obligation that's relevant in this case is the one your client owes under the contract to pay money. If you lose, of course, I completely get the point that your client denies that it does owe money. I understand that. But if it's wrong, then the personal obligation. This is a case about a personal obligation under a contract to pay royalties.
Yes.
And that arises under the contract. This isn't a patent case in which you're being sued for patent infringement. And at least on one view, looking at it that way, one might have thought it falls on the personal obligation side of the line being described there.
My Lord, perhaps if we pick up the New York complaint again, and that was behind supplementary bundle tab 11.
Wait a minute. I'm not trying to, just before we go to the New York complaint, because that's
No.
not this case. The New York complaint is the one you're bringing in America.
We could
In this case, as I
Yes.
understand it, you're being sued under the contract to
Yes.
pay money.
Yeah. And the answer to that, and it equally appears here, it's just that the New York complaint brings it all together tidily, and so is a convenient place to look at it. Clause 9.1 of the RCA, an entitlement to royalties proceeds expressly on the basis that there is a valid claim in a patent covering, and
Okay.
so Otsuka says, appellants.
For my part, I'd like to see how it's put in this jurisdiction.
Certainly.
To see, because this is first and foremost why we're here, isn't it?
Yes.
We came here.
Yes.
So
So on that
what
front,
we're looking for, just so I'm clear, is evidence that the personal obligation on which Otsuka sues depends for its existence on the law of New York. Isn't that what we're looking for? If we take Mr. Justice Parker's phrase, anyway, you show us what you want to show us in response.
certainly. If we could turn to supplementary tab 15. So this was before the judge below. At that stage, there wasn't a defence in play.
This is a letter.
This is a letter, certainly,
Okay.
of the intent, as often arises,
Okay.
and anticipating the question that has in fact just arisen. GW wrote a letter setting out its intended defence in this jurisdiction if it lost on jurisdiction. And if you look at page 226, starting 2/3 of the way down the page, you have essentially the same arguments raised there. So first of all, Pedialex is not covered by any valid claim. And then if it were to be so covered,
Just again, just to be clear, and I understand this, these points that you're referring to, paragraph 25, where there's a summary A, B, C.
yes,
What these are reasons your client contends why the first sentence is wrong. In other words, the first bit of that. So what I'm trying to say is 25 starts by saying Otsuka contends that royalties are due under the contract, da-di-da, and then however, your client denies it for various reasons. But the claim that's being put against you is a claim for royalties under the contract. And
Yes.
you're then setting up these as defences to that.
yes. And we say the principle that comes out of Chugai is that Mozambique has an application insofar as validity is put squarely and directly in issue. And that is precisely what is happening here. First of all, because Otsuka's claim for royalties under the terms of the contract necessarily has to proceed on the basis that there are valid claims in the relevant patents, including in particular US 920. And then in the alternative, that even if Otsuka is right on its claim construction, the claims of the patents are invalid. And this is
Wouldn't the consequence, if you're right, be that a far larger cohort of claims of this sort would come within Mozambique than Lucasfilm seems to provide? Because in one sense, if people in GW's position can always respond to a claim such as Otsuka's by saying, well, the basis of it is a patent in a foreign jurisdiction, which we assert is invalid.
Yes.
Doesn't that, if that is upheld, doesn't that at a stroke remove a large number of claims of this sort?
I think there are three answers to that, my lord. First of all, the doctrine I've shown you in Lear, we would accept is certainly different from practice in this jurisdiction and doctrine in this jurisdiction, and potentially also in others. The European regime was obviously applicable until fairly recently insofar as European patents were concerned. But Lear is unquestionably a product of United States federal policy, and stands for the principles it stands for, which may strike an English lawyer as unusual, but nevertheless they are there and they are very important. The second point is that one answer to why there may not be a plethora of cases along these lines, and this was discussed by Henry Carr, J. in Shugai, very often you see jurisdiction clauses in IP collaboration agreements or similar of this kind, where validity is carved out, but the parties agree that one jurisdiction will resolve infringement and scope, and that typically does away with the problem. Whereas here, and this is, I would say, an unusual feature, the parties, in their wisdom, carved out scope, validity, and infringement.
I don't know if it matters or not, but just so as you know, I don't understand what you mean when you say Lear may seem odd in this jurisdiction. If it matters to your argument, you better explain, because I don't
it does,
why.
and in fact it brings me nicely onto my next point, which is a point that's taken against me, my lord, so that's very convenient. So a second point that is taken, and this really is to do with the nature of Lear and the nature of the approach to patents in the United States, and this was a point that was rejected, and we say rightly, by the judge below, is that the validity challenges that GW raises in accordance with the Lear doctrine will not strictly lead to the revocation of the patent or an in rem remedy, and accordingly they do not qualify for the purposes of the Mozambique rule. And as I say, this was a debate that was had before the judge, and he rightly rejected it. And we have dealt with this in our skeleton in paragraph 25. The key points we make are twofold. First of all, the judge was right, and if I could ask you to turn up his judgment, it's at tab 8 of the core bundle, paragraphs 70 to 71, which is page 98. If I could ask you to read paragraph 70 and 71. And so we say he rightly found there that for a validity challenge to be sufficiently direct for the purposes of a Mozambique objection to bite, there doesn't need to be an in rem remedy, and that distinction is not where the line is drawn.
I understand that, but I don't understand what that's got to do with Lear.
My lord, yes, I'm coming to that.
Okay, sorry.
So the fact that so the first point we make is that for the Mozambique rule to bite, it's not necessary for the validity challenge to have as its object an outcome in rem. Secondly, the fact that proceedings and processes may differ somewhat in a foreign jurisdiction to what we are accustomed to seeing, there is no reason to disapply the Mozambique exception where there is a sufficiently direct challenge to validity. It's common ground between the parties here, and it was common ground in the jurisdictional challenge below, that GW as a patent co-owner cannot apply to the USPTO Patent Office to revoke US 920. That's not a remedy available to it. Its remedy instead is to apply to court for a declaration of invalidity, and that's where Lear comes in. And we say that's no less important or significant of a remedy just because it doesn't necessarily bite in the way that a revocation or a remedy in rem would do so. And there are two authorities I want to show you on that. The first of those is another US Supreme Court decision, Blonder and Tongue, and it's behind tab 18 of the Joint Authorities bundle. The relevant page is page 759 of the pagination. The passage I would draw your attention to starts on the left-hand column of 759 under capital D and continues over the column to Roman numeral 4. And in particular, the paragraph just before Roman numeral 4. Again, discussing the policy in Lear. And essentially finding that once there has been a declaration of invalidity pursuant to Lear, that creates an estoppel in general and not just against the parties to the relevant invalidity case. If you could turn from there, my lady, my lords, to tab 23 of the Joint Authorities bundle. There is some commentary which we would say is illuminating.
What's the date of this commentary?
2017. So relatively recent vintage. And you see in the head note there, Stephen C. DeSalvo, ever since the Supreme Court ruled in Blonder Tongue that issue preclusion applies to prevent litigation on a patent that previously has been declared invalid in a court of competent jurisdiction, courts have applied issue preclusion summarily to end disputes over previously invalidated patents. And really what the author is grappling with is the odyssey of that relative to what one might say was the more natural idea of simple revocation. And if I could ask you to turn to page 856, he picks up the discussion toward the bottom of the page. At first glance, it might seem odd that a patentee loses her property right when a patent is declared invalid by a court, given that the PTO, in other words, the US Patent Office, will still retain a copy of the patent, and there is no requirement to notify the PTO that a patent has been invalidated. And going over the page on page 857, perhaps you'd like to read the remainder of the paragraph there. He suggests that a doctrinal solution to that would be really to treat these invalidity decisions as a remedy in rem, or alternatively to have a statutory requirement that the PTO void any patents that are invalidated in US courts. So to sum up, we say that a validity challenge for the purposes of the Mozambique rule does not need to rise to the equivalent of a revocation or an in rem remedy. But in any event, the remedy under Lear as invoked in the New York action and as invoked here in England as well is one that is close to equivalent in effect within the confines of the way in which patent law works in the USA.
Are you going to respond to Otsuka's assertions that Lear doesn't apply, or probably doesn't apply?
Yes.
Right.
And again, my lord, that's convenient because that was the third point I was going to deal with in terms of the case made against us, and that is the attack on Lear and Lemelson. And for that purpose, I'm afraid we do have to take up some of the evidence that was in front of the judge below. And I'll start with the witness statement.
And basically, as I understand it, what they're saying is it's seriously questionable whether it applies to co-owners at all.
Yes, yes. So if we could start with Mr. Wexler's witness statement, that's behind tab 4 of the supplementary bundle. And Mr. Wexler was the witness for Otsuka. And the relevant section starts at page 62 of the external pagination. Paragraph 36. And you'll see there he says that Lear should be understood within the context of a different doctrine that he calls assigner estoppel. And the case he relies upon is referenced in paragraph 37, a case called Minerva.
And we got that.
It's not in the bundle before you, but there is a summary of the ratio of the case, my lord, at page 39. Paragraph 39, I beg your pardon. Mr. Wexler's view is in the first sentence, which is that Minerva somehow narrows Lear. We would reject that. But toward the bottom end of the paragraph, he cites to the decision in Minerva. So Minerva recognises that there is a significant unfairness for a party who owns a patent to simply turn around and argue that the patent is invalid when that party believes it suits its interest. But we say that this is a narrow example of where equity and unfairness will trump the public policy in Lear. There has to be some inconsistency in dealing for Minerva to apply, and it also arises in an assignor and an assignee relationship. In other words, it does not arise in a co-ownership arrangement such as that under the RCA. And to assist you with those submissions, I'll take you to Mr. Diamond's evidence in response to Mr. Wexler. And this is
maybe those with IT in court are able to look up Minerva. But for my part, I think it would be quite interesting because you're showing us what the American lawyers said about it, and you're not showing us the authority. Which is
and it was
a novel way of, maybe it's not.
It was a task of some considerable difficulty to cut down the authorities that are before you today, my lord, but we can certainly furnish you with a copy of it.
Well, maybe my colleagues don't agree, but I think it'd be quite interesting to see it.
Very good. There are further passages of it quoted in Mr. Diamond's evidence which may assist you, but we will ensure that you get a copy also. So we go to Diamond 2, so this was the witness statement in response, behind tab 6 of the same supplementary bundle. And there is quite a lengthy discussion in here, so I will try to draw your attention to the most salient points. Starting on page 87 under the heading A. In paragraph 18, first of all, Mr. Diamond notes that Mr. Wexler effectively ignored the US Supreme Court's MedImmune decision, which it upheld Lear as recently as 2007. And going over the page, in paragraphs 19 through 23, he lists various decisions in New York State and US courts that have followed Lear. Going to page 90 at heading B, contrary to the criticisms of Lemelson, he says that Lemelson remains good law, and in particular in paragraph 25 he alludes to the fact that Wexler did not identify a single case rejecting or criticising or calling Lemelson into question, and then refers to various authoritative texts that treat Lemelson as good authority. The discussion continues at some considerable length, but if we go to page 98, he then addresses this assigner estoppel in Minerva specifically. And in paragraph 37, at the bottom of page 98, he commences a series of quotes from the Minerva decision, the first of which is there in paragraph 37, standing for the proposition that Minerva is limited in scope. Going over the page to paragraph 40, he deals with Minerva further, but in particular notes and provides a quotation from Minerva that the Supreme Court carefully distinguished Lear. So that case was not a substantial encroachment on the principles that flow from Lear or cases following it. And indeed, going over the page at the top of page 100, he notes that Lear itself distinguished assigner estoppel as something applying specifically within an assignor and assignee relationship. And you see his conclusion there at paragraph 41, that neither Minerva nor any other case modifies or limits the scope of Lear. In any event, we would say that the attempt to attack Lear and its progeny, including by invoking assigner estoppel, rather helps us. Because if a court has to decide that assigner estoppel applies and going against US Supreme Court authority on the point, that is really something with respect that we say a New York court, a US court should be doing, and not an English court, because it would be...
So you say it goes to forum?
Yes, yes. My lady, my lords, I've been going for an hour and a half, and I don't know whether there needs to be a break for the shorthand writer.
I mean, we don't normally have a break, but
Oh, do you not?
we're perfectly
I'm
content to have a break if the shorthand writer would like one, of course.
My apologies. In which case, I will continue. I am moving on to another topic, so it seems like an opportune moment. I'm going to deal briefly with forum now, before handing over to Mr. Gala to deal with active state and public policy. The points raised have been well rehearsed in the party's skeleton arguments, I'm cognizant in making submissions before you that, as we accept, and Otsuka argues, it is rare, although not unique, for an appellate court to interfere with the decision on forum of the lower courts. Insofar as the applicable principles are concerned, we submit that the Spiliada approach requires that the court take a holistic view of all of the potentially relevant factors and the interplay between them to evaluate, rather than exercise discretion as to whether England is clearly the more appropriate forum. And we take this from Briggs, which is at 24 of the Joint Authorities bundle. I don't need to take you to it. We also say that the fact that a dispute is governed by foreign law is a prima facie reason why the courts of that jurisdiction may be more appropriate, including because there can be appeals on points of foreign law and the foreign procedural law will govern. And the point is stronger still if the issues of foreign law which need to be decided are intrinsically difficult, which we would say obviously applies here. Applying those principles to the judge's decision and the facts before you, we say that the deputy judge wrongly discounted the significance of the fact that the dispute is complex, subject to New York governing law, and raising complex and contested questions of New York law and key US public policy on patents. Those questions already involved substantial evidence at the jurisdictional stage, and we would say would be susceptible to appeal generally, assuming they were heard in New York. Instead, the judgment proceeded to give prominence to two factors. The fact that the questions at the centre of the dispute about the nature and extent of the collaboration under the agreement appear likely to be resolved by witnesses located in the UK, and the greater progress already made in this court and the lack of certainty that there will be jurisdiction in New York. On the first of those, GW challenged in evidence the proposition that the majority of the witnesses in the case were to be based in this jurisdiction. Potential witnesses are just as likely to be in the United States, and indeed the examination of the Lear Doctrine, if this court takes jurisdiction over it, will inevitably require substantial input from experts on New York law. We also say that there was and is no reason to suppose that the New York action will take longer to be resolved than the proceedings in London. As I noted at the outset, the trial here is fixed for January 2024, with the CMC only happening next month, while a general directions hearing in New York is set to happen next week, and discussions with respect to discovery or disclosure have commenced in both jurisdictions. You will also have seen in our skeleton at paragraph 38 that we refer to one of the many VTB cases to the effect that the Spiliada principles do not depend on the relative speed of the competing fora unless the excessive delay in the foreign forum amounts to a reason for a stay on forum non-convenience grounds to be refused in the interests of justice. In his reasoning for not declining jurisdiction under the Mozambique rule, the deputy judge also considered that if the proceedings were to get to a stage where the court does have to consider validity of patents granted outside of the UK, that could be dealt with by case management and stays deferring to the relevant foreign jurisdictions. In our submission, that creates the circumstances for delay and not the reverse. The resolution of validity of the GB or UK designated patents would be insignificant compared to the resolution of validity issues relating to the US 920 patent. And again, 95% of all sales of the PDFs up to the end of 2021 were affected in the US, and the US remains and is expected to remain the dominant market for the drug. So resolving issues related to GB or UK designated patents merely determines the royalties payable on less than 5% of total sales. I think the figure for the UK is 1 to 2% of the sales overall on which royalties may arise. And now, the point that may be made against us is that the New York court is essentially in the same position, because claims for royalties are made under patents from a variety of different jurisdictions and not just the US 920 patent. We say there are three answers to that. First of all, from a pragmatic perspective, the resolution of claims in relation to the US 920 patent in a New York court would involve 95% of the quantum at issue, certainly as matters currently stand, and so pragmatically speaking, that might see an end to the proceedings. There is cause to believe that a New York court might take jurisdiction over validity questions of foreign patents, and there is evidence for that in Mr. Diamond's second witness statement. I don't need to take you to that. But perhaps more importantly, we say that the parties' dispute resolution clause here is an indication that they accepted that there may be some fragmentation of their disputes. As we've already discussed and submitted this morning, one often sees jurisdiction clauses that provide for exclusive jurisdiction on questions of scope and infringement, but not of validity, where validity is carved out. Here, somewhat unusually, all three things are carved out. These are sophisticated parties who deal with IP rights all the time, and one can only infer made that choice deliberately, therefore accepting that their disputes may fragment if need be. So, my ladies and my lords, unless you have more questions from me, I'm going to hand over to Mr. Bala on active state.
Thank you very much indeed. Mr. Bala.
My lady, my lords, thank you. This is the part of the argument on active state and public policy, which is, in essence, another way of putting our client's case on the non-justiciability of the matters before the court. And as we'll come on to see from Mr. Justice Henry Carr's comments in Chugai on this point, on the active state point, the question of non-justiciability might depend on how the attack on validity is to be properly characterised. The first rung of this argument is based on the Foreign Active State rule, and the second is based on public policy, which Dicey suggests as a possible alternative analysis. But in essence, these are two alternative ways of thinking about non-justiciability, separate to the Mozambique principle. At first sight, my lady, my lords, it might seem like an ambitious argument given some of the judicial comments about foreign active state and whether it applies in cases like this. Permission to appeal was granted by Lord Justice Arnold on the point, and it's open to us to run it. And whilst there have been obiter comments on foreign active state in relation to registered rights and patents, it's fair to say there has never been a case where this mattered in the result. And here, my lady, my lords, depending on the view this court takes of the Mozambique principle, the answer is it might matter to the result. And we would urge the Court of Appeal in any event to make clear what the position of the law is in relation to foreign active state and the validity of foreign patents. In terms of the structure of the submissions, I'll first deal with the authorities. That might involve 15 to 20 minutes of brief legal archaeology through some of the older decisions and the more recent decisions on foreign active state, and then set out the propositions and how they apply to this case. So, my lady, my lords, if we could turn to Belhaj, first of all, which is tab 14 of the authorities bundle. I'd like to start at page 553 in the bundle numbering, which is paragraphs 61 to 62. And here, my lady, my lords, Lord Mance is describing the origins of the doctrine, referring to the case of Blad and Bamfeld, which is a very old case, 1674. It's summarised at paragraph 30.1 of our skeleton argument. But Lord Mance refers to the fact that the House of Lords in Butts Gas saw the Blad and Bamfeld case as the precursor of the concept of non-justiciability, and an example of the second type of foreign act of state, insofar, Lord Mance says at paragraph 62, as Bamfeld was seeking to challenge the validity of the King's letters patent in Denmark, granted in favour of Blad for the sole trade of Iceland. And I mentioned it, I mentioned this case, my lady, my lords, because It's a point of interest, perhaps not a determinative point, but a point of interest nevertheless, that the origin of the modern concept of non-justiciability and foreign acts of state relates to the grant of patents. Here, letters patent, but of course those are the ancestors of the modern concept of intellectual property rights. So that's the starting point, my lady, my lords. And we then move on to the formulation of the test in Belhage, which we find at paragraphs 38 to 39, slightly earlier, at pages 542 to 543. And in a nutshell, Lord Mance's view of the second rule of Foreign Act of State is that the English court will not question a foreign governmental act in respect of property situated within the jurisdiction of the foreign government in question. And at paragraph 38, he describes it as a special rule of abstention. And there's some debate later on in Belhage about whether it's a rule of non-justiciability or a rule of judicial restraint. I don't think it matters for present purposes, but the way Lord Mance characterises it there is a special rule of abstention, whether the court is declining to pass judgment on the matters before it. I won't take you to where Lord Mance develops it, but simply describe what he says at paragraph 74. He says that it applies where there are sovereign acts seizing or affecting property within the jurisdiction of the state in question at the time the act takes effect. And finally, to show you Lord Neuberger's formulation of the second limb at paragraph 123, which is page 580. And Lord Neuberger's formulation is the second rule is that the courts of this country will recognise and will not question the effect of a foreign state's executive in relation to any acts which take place or take effect within the territory of that state. And the basis of that limb of Foreign Act of State, my lady, my lords, is the basis for all of the limbs now recognised within the doctrine, is comity. That much is clear from the Court of Appeal's judgment at paragraph 67, but it's also clear from Lord Sumption's judgment at paragraph 225. I don't intend to take you there, but Lord Sumption effectively says under the heading the search for general principle that the doctrine is rooted in the principle of international comity, and that underlies all of the separate limbs of Foreign Act of State. Would it be helpful for me to go there, or is the court happy for me to carry on, proceed on that basis?
Entirely up to you, but
I'll proceed. But the reference, my lady, is
225.
225, Lord Sumption. In passing, I should mention, for completeness and out of fairness to my learned friend, paragraph 73.2 of Belhage, where there is the reference to Lucasfilm. And there, it is recorded there that Lucasfilm, intellectual property rights have been held not to engage foreign acts of state solely by reference to Lucasfilm. But we'll come on to Lucasfilm and what it actually decides.
73, Roman 2.
Yes, that's right. In the Roman 4, apologies.
Oh, right.
And again, it's the judgment of Lord Mance.
In a sentence, how are you going to get around that?
Well, coming on to it.
Okay, it's going to be more than a sentence. It's going to be a few paragraphs, is it? Right, I won't. Okay.
Yes, I didn't intend to say anything else for now about Belhage, unless the court wanted me to. I wanted just to set out the scope of an ambit of the second rule as it's set out in Belhage. And now to come, my lady, my lords, to Maduro, which is the most recent Supreme Court exposition, very recent, and this is tab 16. This is the famous case about the Venezuelan gold. And again, just a brief reference to the judgment of Lord Lloyd Jones, paragraph 135, which is internal page 706. And Lord Lloyd-Jones, I think it's fair to say, crystallises the second rule, which after Belhage was not entirely certain whether it actually existed or not, but Lord Lloyd-Jones says in no uncertain terms that it does, in the following way. The courts in this jurisdiction will not adjudicate or sit in judgment on the lawfulness or validity under its own law of an executive act of a foreign state performed within the territory of that state. And he goes on, Lord Lloyd-Jones goes on to say that it's founded on the respect due to the sovereignty and independence of foreign states and is intended to promote comity in interstate relations, echoing the justification for the doctrine that Lord Sumption and Lord Mance set out in Belhage.
I mean, you say it's not clear. It's exactly what Lord Newburgh said in Belhage, almost word for word.
Yes. Lord Newburgh left some room open as to whether as to the cogency of the second rule and the exact precise circumstances in which it might apply. And so I think it's fair to say that this is a crystallisation of what Lord Newburgh was identifying in Belhage. But the two points I'd like to focus on is the lawfulness or validity under its own law and the justification of comity. Now again, to be fair to my learned friends, at 136,
7.
At 7, Lord Lloyd-Jones goes on to again record that the Acts of State Doctrine should not be an impediment to an action for infringement of foreign intellectual property rights, even if validity of a grant is an issue, simply because the action calls into question the decision of a foreign official. Again with the reference to Lucasfilm, and also with a reference to the decision in UCOS Capital, which is a decision of Lord Justice Ricks, to which I now refer the court at tab 11. Apologies for taking the courts to so many of these, but I think it's important just to see the genesis of where this line of reasoning has come from. UCOS, my lady, my lords, was a case about the enforcement of an award, of an arbitral award, that had been set aside by the supervisory Russian courts. It's a case that has nothing to do with intellectual property or patent law. It's a case about enforcement. And in a nutshell, the role of the Act of State argument is that Act of State was said to bar accusations being levelled against the Russian state, calling into question the lawfulness of the Russian state's acts under Russian law as part of the enforcement debate before the English court. So that was the context. And at paragraph 63 to 64 of UCOS, which is bundle numbering 293 to 294, with the red highlighting, you'll see, my lady, my lords, that Lord Justice Ricks refers again to Lucasfilm, to the reasoning in Lucasfilm, and to the judgment of Lord Walker and Lord Collins. And so an approval of what is said in Lucasfilm, no independent analysis, nor was the point at issue in UCOS at all. So now finally, my lady, my lords, Lucasfilm itself at tab 8 of the authorities bundle. And it's important, my lady, my lords, to understand what Lucasfilm did decide and what it did not decide. And if we can pick it up at paragraph 50, which is internal page 160 of the bundle numbering. Where the court says as follows: the issue on this aspect of the appeal is a narrow one, whether the English court may exercise jurisdiction in a claim against persons domiciled in England for infringement of copyright committed outside the European Union in breach of the copyright law of that country. So a copyright case, my lady, my lords, and a narrow question is at issue. And the nub of the of the reasoning in Lucasfilm on this particular point is at paragraphs 82 to 86, a short while down, which is bundle numbering 167 to 168. Where some of the foreign decisions, the decisions from foreign jurisdictions are considered, including some of the US decisions. At 85, the Australian decision of Potter and Broken Hill, where the High Court of Australia decided, albeit in 1905, that the Foreign Act of State rule did apply to bar the consideration of the validity of foreign patents. The reference at 86 to the Gennard report and the decision of the European Court in the Gesellschaft case. And then really this is it, my lady, my lords, at the end of paragraph 86. But in England, the Foreign Acts of State doctrine has not been applied to any acts other than foreign legislation or governmental acts of officials such as requisition, and it should not today be regarded as an impediment to an action for infringement of foreign intellectual property rights, even if validity of a grant is an issue, simply because the action calls into the question the decision of a foreign official. Two points on paragraph 86, my lady, my lords. The first is that they are undoubtedly obiter. Mr. Justice Henry Carr accepted that much in Chugai at paragraph 52. Indeed, it's Dicey's view as well that Mozambique doesn't shut out the question. Dicey's view, which is recorded in Chugai, is that Lucasfilm leaves that question open to be decided. So it's obiter, number one. Number two...
Have you got that extract from Dicey here?
It's in the bundle, my lord. Yes, we'll just get the reference. I believe it's the 15th edition reference.
That would be Lord Collins wearing his author's hat.
Yes, quite right, my lord. Yes, it's tab 22B of the bundle, my lord. And it's section 34.
Page number.
Page 797 in the bundle numbering for the authorities bundle. 34027, section 34027, where the editors of Dicey state, where a foreign right is relied on, it remains to be decided whether questions as to the creation, validity or transfer of foreign intellectual property rights dependent on a state grant, such as a patent, are matters which are non-justiciable before an English court. This point was left open by the Supreme Court in Lucasfilm, where the existence of such a rule for copyright and other non-registrable intellectual property rights was denied.
So are you taking us to the footnote refers back to Lucasfilm and to other paragraphs? Were you coming on to that?
Yes,
the footnote says 101 and 115.
Yes, fortunately, my lord, that takes us to Lord Mance's view on the point, which is where I was going to go next,
okay.
Which is, in fact, broadly in support. In fact, why don't we go there, my lord?
Just before you do, out of interest,
yes.
I'm assuming, since you're showing this to us, that it's also in the 16th edition of Dicey, not the 50th.
Yes, my lord, I was going to come on to that. So the 16th edition is in the next tab. I can take the court to it now, or we can deal with it later.
That's just arrived.
It's just arrived a matter of, I think, something like 3 weeks ago, so it's hot off the press.
Unpacked last week.
Yes,
so.
this may be the first reference to it, who knows. But we'll go on to that if that's all right. If I could take my Lord Justice Baker's invitation to go to paragraph 115.
Well, the 15th edition of Dicey,
yes,
it refers to 101.
101,
which is
yes.
in Lord Walker and Lord Collins's judgment.
Yes.
Where it says, do not take issue.
Yes, but by reference, my lord, to Mozambique. Dicey, it's fair to say, is talking about both foreign acts of state and Mozambique as concepts within the broad parameters of non-justiciability. But again, at 101, the court of the court is here saying that the issue again is very narrow, which supports what Dicey is saying about the scope of what this case is, of what Lucasfilm is in fact deciding. Paragraph 115, Lord Mance. In fact, the last word in all of the judgment. I expressed no view about the application or scope of the doctrine of act of state in relation to issues of validity of foreign intellectual property rights, which, unlike copyright, may be said to depend upon state grant. So there, my lady, my lords, we have not only Dicey recording that Lucasfilm leaves the question open, but also no less than Lord Mance stating that there's something in the argument. Now,
well, he doesn't express.
Well,
up
We
to
can
that
all
point.
see what he says.
to a certain extent, he's raising the possibility that the argument might run.
Expressing no view.
Yes. And that, my lady, my lords, is really it. That is what is then taken forward. That statement of principle, if indeed one can call it that, is then taken forward and used, or one might say recorded, in the later decisions as to whether the doctrine in fact applies to bar the consideration of questions of the validity of foreign patents. Again, going back to Lord Mance's formulation 115, the scope of the doctrine of acts of state in relation to issues of validity, not whether validity is directly challenged, but issues of validity.
Were you going to take us to Dicey 16?
Yes, I can do so now, my lord. I'll do so now
because
before I get
obviously
to yes,
the passage in Dicey 15,
yes,
which precedes the footnote 191, and which is the
Yes.
passages in Lucasfilm to which you've just taken us,
yes.
is followed by further observations by the authors of Dicey.
That's right.
I think, for my part, we should see whether that's what the position is now, according to Dicey. Say 24, do you? No.
Yes, so 22C is the bundle reference for the latest edition of Dicey.
What page number?
That's paragraph 2613.
I'm not sure I've got the 22C.
It may start at page 800, my lord, within the authorities bundle tabs. I think it was a later addition to the bundle.
Yeah. Is it the same paragraph number as the 15?
It's not. It's somewhat confusing, and we were not able to find in the equivalent the ordering has changed. And
they've had a big rewrite of the book.
It appears there appears
What's
to be.
happened is that they've got a new chapter. No doubt the salesmen are very keen on it. A new chapter on intellectual property, which this is down in.
Which this is.
I'm sure it'll add to their sales.
Yes. So 2613 is the new version of this, and well, would the court like to read it to itself? And my lady, my lords, the aspect of this version of the analysis we would point to is the Supreme Court in Lucasfilm left open the application of the Mozambique rule to claims involving registered rights, and in particular claims concerning the validity of registered rights. It's right to say that this version, this particular analysis of Dicey is less unequivocal on the foreign active state. I must accept that. Than the
follows
previous
Chugai, of course,
Yeah.
which post-states.
It does. But I was going to come to Chugai, my lord, to really see what Chugai is saying about it. But as far as we could tell, this is all that the current version of Dicey says about these points in the new intellectual property chapter. But at the very least, my lady, my lords, notes the doubt so far as Mozambique is concerned for claims involving registered rights, and in particular claims concerning the validity of registered rights. And again, the word concerning, not a claim directly to hold that a foreign patent is invalid, but claims concerning the validity of foreign patents, of foreign registered rights. My lady, my lords, could I now take the court to Chugai, and I'll do this as economically as I can. It's the last authority I wanted to take the court to. It's tab 15, we've been there before. And the relevant passages of Chugai are at paragraph 61 to 74, which is bundle number in 657 to 661. And in a nutshell, Mr. Justice Henry Carr refers to Belhage, the passages of Belhage that we have looked at, notes that the comments in Belhage were obiter, accepts, as I mentioned before, that the comments about patents and registered rights were obiter. But ultimately, Mr. Justice Henry Carr finds that acts of state is not an impediment to an action for infringement of foreign intellectual property rights, even if the validity of a grant is in issue. Paragraph 68. But then curiously at paragraph 69, in the explanation as to well, the header is application of the Act of State doctrine to the present case. In the reasons given for why the Act of State doctrine does not apply, Mr. Justice Henry Carr refers to comity and the presence of the English exclusive English jurisdiction clause, and the fact that comity would not be offended in that situation because of the presence of the English jurisdiction clause. Of course, now not a feature present in this case. And from paragraph 70 to 74, Mr. Justice Henry Carr then goes on to pick up on that point and to expand it to what he calls the wider question. In the absence of agreement, i.e. in the absence of an English jurisdiction clause, and he refers at paragraph 71 to Briggs, and the statement, the grant of a patent is closer to an act of sovereign power than many, and then concludes critically, my lady, my lords, at paragraph 73, that in my view there are powerful arguments that such direct challenges, where validity is the principal issue, are not justiciable. And then goes on to note some pertinent factors, including the distinction between infringement claims and patent claims, a reference to the fact that patents are monopoly rights in rem, a reference to the Brussels regulation and the allocation of jurisdiction within the Brussels regulation, which the court will be familiar with.
That doesn't apply, does it, in this country now?
No, my lord, and it doesn't apply in this case.
It's not even retained law. It's actually not a law.
I believe that's accurate, my lord.
There are some very small bits of the Brussels Convention which were put into an act, but they relate to consumers and some other things, but the rest of it is just not our law anymore.
Yes, yes.
Does that make any difference to the point you just made?
My lord, really it's used in our case by way of analogy. It's used in that particular jurisdictional regime in a similar way, where under the Brussels regulation, we can go to it. I was going to come to it right at the end of my submissions. where under the Brussels regime, proceedings are concerned with the registration or validity of patents or similar rights required to be deposited or registered, that is a matter for the exclusive jurisdiction of the courts of the member state in which the deposit or registration takes effect. Now, the underlying logic for that, or there might be several underlying logics for that, but one of them is comity, but the other, we would say, is a similar principle, a recognition in the European regime, as much as we would say ought to apply in the common law for an act of state doctrine, that some of these matters and the validity of foreign patents, matters concerning the validity of foreign patents is one, where these courts should be determined by the relevant foreign court. So even here in Chugai, my lady, my lords, even with Mr. Justice Henry Carr's apparent conclusion at paragraph 68 that the Act of State doctrine is not an impediment to an action for infringement, that appears to then be influenced by or premised on the presence of the English jurisdiction clause and comity concerns at 69, and precedes this much more equivocal passage from Mr. Justice Henry Carr on what might happen where validity might be said to be directly challenged. Query what directly challenged actually means. On one view, that's the issue at the heart of this appeal. But insofar as Mr. Justice Henry Carr is concluding that the Act of State doctrine does not apply, what we urge on your lady and your lordships is to focus on what is said in 69 on the presence of the English jurisdiction clause, and what is then said at 70 to 74, which goes back to everything that we've been submitting about comity, about the concerns that apply in this area. So even Chugai, which itself is premised, if one can use that word, on some of the older decisions, Mozambique, and then you have Belhaj and you have Maduro. Even Chugai contains hints of reasoning in the opposite direction, more than hints.
Well, drawing the threads of your combined submissions together, you're saying that his distinction between the distinction between paragraph 68 and the last paragraph is wrong, and you would say the Act of State doctrine is not an impediment to an action for infringement of foreign intellectual property rights unless the validity of a grant is in issue.
Quite right.
You together are saying the idea of having a direct challenge is illusory if it's an issue.
That's our submission.
It comes within it comes within Mozambique.
Yes.
And B, it's covered by the Act of State doctrine.
Yes. Yes, my lord. That's the submission. And so if I could,
that's your submission. What does in issue mean in that context?
Yes. Well, my lord, that's as I mentioned, that's on one view the critical question in this appeal. Various cases and various commentators have put it differently. Briggs, I believe it was Briggs, calls this a genuine dispute as to validity. I've been trying to emphasise as I went along some of the ways in which, for example, Lord Mance, who I believe we can go back to, a question as to validity, or an issue as to validity. Should we go back to Lord Mance?
Speaking for myself, I don't think you need to.
Yes.
I mean, let me tell you what puzzles me about the point you're making. As I read paragraph 68 and 74 of Mr. Justice Henry Carr's judgment, what he's saying in 68 is the Act of State doctrine is not an impediment to an action for infringement, even if validity is an issue. And then at 74, he's saying effectively what it would be an impediment to is a direct challenge to validity in the English court. So that's the contrast he's drawing. Now, everything depends on the difference between a direct challenge to validity of a foreign patent and what validity in issue means. Now you've very elegantly submitted that there's an inconsistency to do with between these two, and I'm not understanding what the inconsistency is unless you answer the question, what's the difference between being an issue and a direct challenge? Because he's drawn the line that way, and drawing the line that way doesn't seem to me at any rate. The two paragraphs are inconsistent with each other.
Yes, I see that, my lord. It's a question ultimately of drawing the line and characterisation of the challenge. The way in which the challenge, we say, should be characterised in this case, even in circumstances where it might arise in the context of a dispute under a contract, under a licence, the way in which the Lear challenge, we say, operates is in effect as a direct challenge. The issue is raised directly. Is US 920 valid or is it invalid? So it's difficult to answer my lord's question because because Mr. Justice Henry Carr doesn't quite explain what he means by the validity directly being an issue.
Well, let me tell you what I think he means. It's a frequent occurrence in a patent case to hear an alleged infringer, and your client in that sense is an alleged infringer, contending that the true construction of the claim can't be the one that covers me, because if it was, it would be invalid. They don't necessarily challenge validity, they simply make that point. Now, that point I've seen is in the US complaint, and I assume it's in your defence. I haven't checked it, but I rather think you're probably making the same point in this jurisdiction. That kind of argument, as I understand Mr. Justice Henry Carr's decision, he puts in the para 68 side of the line. And I don't understand whether you agree or disagree with that. I know you say that you have another argument, which you call the Lear argument, not quite sure why, but that's maybe not the issue, where you say you actually want to positively say the patents are just invalid, and that you characterise as a direct challenge. I suspect rather think it probably is, or very close to it anyway, and that would be barred. That's not grappling with the point that you're trying to make in this court, which is that the decision that the court can adjudicate on the dispute, which certainly includes what I'm going to call, he didn't, an indirect challenge, to contrast a direct challenge.
Yes.
But I think you're trying, just to be absolutely clear, what I think you're trying to do, and this is why I'm struggling, is say that any time your case is, that any time the word validity pops up, it's not to be done.
That's not our case, my lord.
Right.
Because validity can arise in different ways. I mean, validity may arise incidentally as an aid, for example, to construction, as it has in some of the other cases. Chugai is the best example, probably. Yeah. Validity can arise in the way that it arises in the sense of Lear, which, as my lord says, is in a more direct sense. My lord, the way where we would draw the line is if there is some relief sought in the English proceedings, or depending where the foreign court is, positive relief is sought declaring that the patent is invalid or equivalent, then that is sufficiently direct, and that is the sort of direct challenge or attack that Mr. Justice Henry Carr is talking about from paragraph 70 to 74.
Okay.
So it turns on relief. If relief involves relief against the direct, is against the validity.
Yes, my lord. I mean, that seems like a sensible place to draw the line.
So it wouldn't cover a case where a finding of validity is necessary for other relief.
If my lord, yes. If it were a collateral finding on a logical process to some other form of relief.
It's not just relief. It's not just relief. It's more than that. It's a necessary. It is a necessary. It's a necessary finding towards the relief. Is that what you're saying?
My lord, I think we would say ultimately the question is in the relief, is there positive relief or negative relief sought as to validity? So that's the first step. There may be situations in which the court must make a declaration about validity to then go on to the further parts of the relief sought. That might be a question of degree, my lord. But I see my lord might be concerned about possible arguments about floodgates and the types of cases that might be caught by this. And there are a number of answers to that point, some of which Ms. Byrne gave.
mean, Mr. Barr, I'm interested in that submission because, at least as far as I'm aware, there is no such relief sought in this case.
Can we go to it, my lord?
Cool. I'm looking at the prayer for relief in the particulars of claim.
Yes.
I mean, it wasn't meant to be a controversial place to look.
No. That's the core bundle. Tab 10. And it's the prayer for relief.
126.
126, that's right. Yeah.
I mean, these are all declarations about the contract, aren't they?
My lord, yes, paragraph, well, item 3.
I'll be showing the court, but they're all framed in terms of expressions in the contract.
Item 3, my lords, is the premise for items 1 and 2, covered by a valid claim of the relevant patents and territories in which they are and or have been in force.
What?
It perhaps comes out slightly more clearly in the letter that was sent in supplementary bundle 15, tab 15 of the supplementary bundle.
Right.
This is the
This is the defence letter.
anticipated defence.
Yes.
Just in the defence, just to be clear, that we have
Yeah.
now got a defence, you filed one, and I don't see that it doesn't have a counterclaim for any declarations at all, unless I misread.
My lord, we would say within paragraph, within item 3 of the prayer for relief, that's in my submission is that raises the issue of validity or amounts to a direct. Of course, it doesn't go into as it can't.
I mean, it's got the word valid in it. I understand that. I don't recall, and I'll be corrected. It'll demonstrate that I've misremembered the judgment. I don't recall that point being made to the judge, but if it was, apologies.
Which point, my lord?
Well, is there, as I said, if there is, I apologise, I've forgotten it. Is there a paragraph in the judgment where the judge addresses a submission that paragraph 3 represents a direct challenge to the validity of for a declaration of invalidity of a patent? And as I said, I may well be wrong, but I don't remember reading that point being made.
Yes, can we come back to you on that, my lord?
Yes, we want to look at the counterclaim in the last sentence, the last paragraph, do you? On page 228.
228.
Of the letter.
Yeah,
This is not the claim, this is your counterclaim for a declaration.
Yes, my lord. Paragraph D, 36D at page
And
228.
E, C and D.
C and D.
C is the same as 3, as the
Yes.
counterpart of paragraph 3. And D, I grant, D is a claim for a, I guess it's a declaration. But you haven't made that counterclaim, at least as far as I can see.
Yes, my lord. Well, the submission is there. I mean, the prayer for relief obviously doesn't unpack the concepts because it's a prayer for relief.
Okay, thank you.
So, my lord, to draw the threads on everything I've been submitting together, the proposition that we would invite this Court of Appeal to accept is that the grant of a patent is an exercise of sovereign authority occurring within the territory of the foreign state, intended to have effect in it, issued in accordance with the foreign state's particular patent legislation. See Lord Manson, Lucasfilm. See Briggs, the grant of a patent is closer to an act of sovereign power than many. See the Gennard report. I won't take the court to it, but the Gennard report states, since the grant of a national patent is an exercise of national sovereignty, Article 16.4 of the Judgment Convention provides for exclusive jurisdiction. C, the recast regulation by analogy. C, the GATT case, which is at footnote, this is the European case at footnote 16 of our skeleton argument. And all of these issues, the grant of a patent, my lady, my lords, raise acute public policy concerns because it is the territorial grant of a monopoly right arising out of a decision, an act, an executive act of the foreign state in order to protect the industry of that foreign state and the courts of which that foreign state would typically be expected to determine questions of validity. And so as a matter of principle, as a matter of theory, all of the comity concerns that underlie the Foreign Act of State doctrine ought to apply in this context. The only reason why they don't at the moment is various obiter comments relying on the obiter statements in Lucasfilm. But the punchline, my lady, my lords, of this submission is that a challenge to the validity of a patent is in substance a challenge to a foreign act of state. Certainly where that challenge to validity is direct, and that can be in the form of a positive claim or a defence that logically must have that conclusion. And we would invite the Court of Appeal to make the position clear in this regard. The current state of the law is unsatisfactory, emerging out of the obiter comments in Lucasfilm. And one possible analysis might be to hold that, to accept that in principle, the Foreign Act of State doctrine is engaged so far as questions of the validity of foreign patents are concerned, subject to, as was formulated in Belhaj and in Maduro, robust exceptions where it can be said that the validity challenge does not rise to a sufficient threshold. So really we say, my lady, my lords, that the position should be opposite. The position should not be sort of blanket statements with little analysis saying that the Foreign Act of State doctrine just doesn't apply to questions involving the validity of foreign patents. It should be the opposite. The Foreign Act of State doctrine is engaged for all the various reasons.
Why do you say, how would you justify the distinction between copyright or some forms of intellectual property right and others? So copyright versus patent. What's the difference? The patents are subject to a process of state simply because they're issued by, a patent is issued by a state or registered with a state.
That's right, my lord, but it's not an unimportant feature.
Okay.
In Lucasfilm, that's
I say simply that's the point.
Yes, well, in Lucasfilm, that's the point they make about why the case is decided in that narrow way.
Why is it a good distinction? I mean, I understand in Lucasfilm it was a copyright case, so they didn't have to decide what to do about registered rights, so they found a reason not to, and did. But whatever the position was in Denmark in the 17th century, in the United Kingdom in the 21st century, the exercise of whatever sovereign power it is granting a patent, if it is so heavily circumscribed by law that the state is not entitled to not do it if the applicant fills in an appropriate form and the form and the content of the material satisfies the relevant law. So the grant of the patent is not a discretionary exercise in any kind whatsoever. It is an automatic exercise undertaken by a state agency doing so. So whereas one can quite understand why in the olden days, if I can call it that, letters patent granted by sovereigns, which were exercises of discretionary power, would be seen as an act of state in the sense that these cases are talking about. The modern grant of a patent isn't anything like that.
My lord, yes, but there are other features. The fact that, notwithstanding my lord's point, the fact that the effect of the decision is still and always has been to create a monopoly in the right, which has territorial effects within the jurisdiction.
That doesn't draw a distinction from copyright. I mean, I know some people will argue that there's a difference. There's a different kind between the monopoly created in copyright and in patents, that's true, but it's still both monopolies. Both arise through the operation of the law, although one you need to fill in a form and send the right form to the right government department, and the other you don't. that distinction I'm putting to you doesn't help.
Yes, well, my lord, it's a distinction that was certainly made in Mozambique. Even in the context of the modern approach of the Patents Court and the approaches of the courts to similar questions, Fran licenses, for example, Unwired Planet and Huawei, which isn't in the bundle. But even in that context, even with the recognition that these questions are now more international than before and perhaps shouldn't be trammelled by common law principles, there is even a suggestion in Unwired Planet that questions of validity are separate in the Supreme Court's decision in Unwired Planet. There are other decisions, my lord, that are not quite as old as 1673. One is the decision of Mr. Justice Aldous in Plustus Creative, which is actually referenced in the coin controls case, which is at tab 5. Mr. Justice Ladd, I won't take the court there, but that's somewhat more modern. I think 1991.
Well, I don't want to. Of course, I'm not teasing you at all. But can I just explain what's in my mind?
Yes.
What I'm sceptical about, which is the point of my question, is the irrelevance of the active state doctrine. That's a different thing from whether public policy considerations, in a general way, lead probably to the same result. But what I'm focusing on is this active state concept as being a useful one in the context of this discussion.
Yes.
Which is the point you're making, which is why I'm putting it to you.
Well, my lord, I point to the redefinition of the doctrine as set out by Lord Neuberger and Lord Mance and Lord Sumption, and subsequently by Lord Lloyd Jones. And if one simply takes what, in essence, the second rule of the Foreign Active State doctrine does, and the Supreme Court was invited to find that the Foreign Active State doctrine did not exist in Belharch, and it found that it did, and it restated it. So if one simply takes the second rule, and one analyses the second rule, all of the criteria in the second rule are met. And one also has the points about monopolies, about effects on local populations, etc. And so and the comity concerns, my lord. So I think that's everything I had to say, unless the court has anything further.
Thank you very much indeed, Mr. Bala. Now, do you want to start now or afterwards?
I'm in the court's hands on that, so I have no preference. I'm happy to get going.
Well, let's get going then.
My lady, my lords, we submit that this appeal should be dismissed. My client Otsuka's claim is in both its form and its substance a contractual claim. It is founded upon and it seeks to enforce a personal contractual obligation of GW Pharma to pay money to my client Otsuka, specifically a royalty on sales of Epidiolex. GW Pharma are, as the judge explained, two English companies. They have their offices in Cambridge. They've been served with these proceedings as of right in the UK. The contractual royalty entitlement relates to a product, all of which is grown and manufactured here in the UK for the whole global supply. But most critically, as we should be seeing, the key factual dispute for trial on GW Pharma's own defence will be what precisely occurred or did not occur during a research collaboration which took place between the years 2007 and 2013, almost entirely here in the UK, particularly in conjunction with academics at the University of Reading, all of which was funded by my client, Otsuka. That's going to be the key factual investigation, as I'll show you in due course. And it means, of course, that all or most of the relevant witnesses are here in the UK. Now, as is very common with multi-jurisdictional patent licenses, the royalty obligation of GW Pharma was triggered only if there was a valid claim, capital V, capital C, as defined in the agreement, in a particular jurisdiction of sale that would have been infringed but for the licence. And I'll show you the provisions after lunch. That was the parties' bargain, their contractual bargain. Under the agreement, valid claim capital V, capital C is defined as a claim which has not been finally revoked by a court of competent jurisdiction. So the agreement itself obviates consideration of validity issues in order for it to be capable of enforcement on its express terms. Again, as we'll see from the Chugai case, that's actually a very common structure in these sorts of agreements. But my client's claim in a nutshell, a contractual claim, is that the product is a GW Pharma product, as defined in the agreement. Again, I'll show you the definitions. That it falls within the scope of the 11 patents pleaded in the particulars of claim, which are, and it's worth emphasising, 3 UK patents, 2 German patents, 2 Swiss patents, 2 Australian patents, 1 Israeli patent and 1 US patent, and that Otsuka accordingly owes my client a contractual obligation to pay royalties on sales in those jurisdictions. That claim has been perfectly properly brought in this jurisdiction against GW Pharma, served as of right. Because it was served as of right, the burden lay on my learned friends to establish some basis for declining to exercise that jurisdiction. The High Court rightly found that no such basis had been shown. And likewise, on appeal, in my submission, no basis has been identified for interfering with the High Court's judgment. And after the short adjournment, I would propose to go through the 3 main topics with a view to making that submission good.
Thank you very much. We'll rise and resume at 2.
Court's rise.